name is Jocelyn, and I'm your conference manager today. If counsel on either side of the case or a judge drops from the conference, I will announce it and we will pause the proceeding and clock. The dropped individual should attempt to rejoin as quickly as possible. Please contact me at the number at the top of the court sheet should you have any trouble reconnecting. The courtroom deputy will ring a bell that sounds like this. When counsel's total allotted time expires. Judge King, the participants are ready. May the courtroom deputy open court?
Yes, the courtroom deputy should open court.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. Judge King, first case is 20-7797, U.S. versus Curbo.
Thank you, Madam Clerk. And our attorney for Mr. Curbo is Ms. Lyston. Have I pronounced that correctly?
Yes, Your Honor.
Good to have you with us, Ms. Lyston.
Good to be here, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court, Jenny Lyston for Gary Curbo. Your Honors, the government's delay in certifying Mr. Curbo is not reasonable because the government had everything it needed to certify Mr. Curbo well before the commitment period expired, and it has failed to explain why it did not do so. When the Mississippi District Court declared Mr. Curbo incompetent on July 26, 2018, the government knew the following about him. It knew all about his offense conduct and what he was charged with. It knew that he was mentally ill and what his diagnosis was. It had in hand an evaluation from its own expert opining that not only was he incompetent, he could not appreciate the wrongfulness of his actions, so the government knew they would be unlikely to secure a conviction in this case. They knew his arrest history, his prior interactions with law enforcement, his prior psychiatric hospitalization. They had custody and detention reports. They had all the observational.
Okay, Ms. Leaston, this
Yes.
is Judge Thacker. So at that point, from July 26th, under your view, then they needed to complete their evaluation within 4 months, correct?
They needed to assess whether he could be medicated under the 4241D1 period.
Okay. I guess my question is the timing. It's within 4 months, right? And that would have ended in November, correct?
That's correct, Your Honor.
But they
And what had to be done within 4 months? What was it that you say had to be done within the 4 months?
The 4-month period under 4241D1 is to assess whether that person has a condition that lends itself to restorability. So
That's a competency issue.
So he's already been declared incompetent.
Isn't that the competency issue?
That is his restorability issue, whether he can be medicated.
They have to decide whether he's competent. The first thing they have to decide whether or not he's competent. Before they can into whether he can be restored to competency, they have to decide whether he's competent.
Yes, Your Honor. That had already been declared. The Mississippi court on July 25th, 2018, declared him incompetent. So he had already been declared incompetent. And so going into the 4-month under 4241.
That's right. He had to be, they had to decide whether he was competent first. They said he was incompetent. Then they had to figure out whether he could be restored to competency. They weren't dealing at all with the extent he was dangerous at that point, correct?
Well, so the assessment of his risk, Your Honor, we believe is implicit under 4246. When you have a person in your custody under 4241.
Well, you're talking about statutes. It pretty much usually needs to be explicit rather than implicit.
Well, the director of this facility where the person is hospitalized, Your Honor, has to assess whether or not that person would pose a risk if released. And when they get to the end of the 4-month period, Your Honor, they have to release him unless They, at the end of that 4-month period, unless they have a substantial probability finding from the district court that says, okay, you can now medicate him and go on to a further.
Ms. Lyston.
Okay, and
Yes.
that gets, oh,
Listen,
Ms. Lyston.
I ask you something.
Ms. Lyston, this is Judge Traxler. I just want to clarify before you go any further, the answer to Judge Thacker's question. Is your position that the 4 months starts running on July 26th?
Yes, Your Honor. At the time of the commitment period begins when the district court commits him.
Which is July 26th. Is that your position?
July 25th, 2018, Your Honor.
Okay, thank you. You answered my question.
Yes, Your Honor.
okay, and then I have a follow-up question. So then that 4-month period would have ended in late November, and yet Dr. Riley didn't complete her evaluation until December 19th. And that's the point at which you argue he should have been released. Is that correct?
So we believe that the 4-month period begins to run, Your Honor, from the time of the district court's order. So we believe that the time
Now, which
ran.
order? You're talking about Judge Britt or the judge in Mississippi?
No,
Oh,
when the Mississippi court committed him to the custody of the Attorney General on July 25th, 2018, we believe that.
Okay, that's what you, before you said that was the commitment court, but in these briefs and things, a lot of them call that the criminal court. And they call Judge Britt in the Eastern North Carolina the commitment court. Isn't that right?
So
these are new terms that are, whether I guess they're unique to these kinds of things, but you got two courts here.
We have a
And indeed, you got two sets of lawyers. Before you got into this case, he's got a lawyer that represents him in Mississippi.
That's correct.
And he
Your Honor.
agreed. And he agreed with the government to the initial commitment, totally and without reservation. Isn't that correct?
So, Your Honor,
Isn't that correct?
Absolutely. They jointly moved.
That's absolutely
They jointly
correct.
moved to for him to be evaluated for competency. That was on as soon as he made his initial appearance. It was very obvious that he needed treatment, and so
And his lawyer agreed to it and moved for it. And,
both of them did. The government and his attorney, Your Honor.
And his attorney, that's right. And you're in it for the special purpose of whatever's happening to him in the Eastern District of North Carolina. And his real attorney is out there in Mississippi for the criminal case.
For the criminal case in Mississippi, yes, but we are dealing with his civil commitment here, Judge King.
And this is ancillary to the criminal case.
The criminal case we are not dealing with, Your Honor, because he has now been civilly committed. And we
Yeah.
can, yes, Judge Traxler.
Can I follow up? This is Judge Thacker again.
Thacker,
Can
sorry.
I try to follow up my line of thinking again? So July 26th starts the 4241 D1 4-month period, and that ended in November.
Correct.
So once Dr. Riley completed her evaluation in December 19th, 2018, that was beyond the 4-month period.
That's correct.
So shouldn't
what
he
you
have
about-
been
what you
shouldn't
about
he
the
have
fact-
been released?
From Mississippi to North Carolina.
I'm sorry. I'm not sure, Judge King. I did not hear your question. I was trying to hear the end of Judge Thacker's question.
I'm sorry. You all are agreeing on all these dates, and nobody's talked about the travel time that it took to get him from Mississippi to the Eastern District of North Carolina in 2018. Was that a part of the commitment time, or is that not part of the commitment?
Judge King, our position is that is excluded from the 4241 D1 period, and that's because if you just left it up to the government to decide when you can ship someone, you could keep someone indefinite commitment, sort of indefinitely, as the government did here, to decide when it wanted that 4-month commitment period to begin. Also, if Congress wanted.
So tell me again. The time period between Mississippi and North Carolina to get him here is within the 4 months or outside the 4 months?
That is outside the 4-month period, Your Honor. We believe that the commitment period begins.
Well, I thought you were saying it was part of the 4 months. That's exactly what I just thought you just. You gave this first answer, but then your explanation was inconsistent with it.
I'm so sorry, Judge King. I don't mean to be unclear. The 4-month commitment period begins when the court commits that person to the custody of the Attorney General, and then it automatically expires by virtue of the statute 4 months later. We don't think that the government gets any extra time for travel. You know, if Congress
there's no requirement for reasonable. There's no requirement or leeway for reasonableness in that 4-month period, right?
Correct, Your Honor. That is a 4 month. That's all you get.
Then he should have been. So then he should have been let out, and just assuming that the 4 months had lapsed as of December 19th, your position is he should have been released at that time. My question is, would he have been subject to pretrial detention or some other detention at that time, such that your argument would be such that it would be harmless not to let him out at that point?
No, Your Honor, he was not subject to any pretrial detention because he had not yet had a detention hearing. So he had not had a detention hearing under the Bail Reform Act.
Couldn't the government just take him into custody for the purpose of the pretrial detention hearing, since they hadn't yet gone through that analysis?
If they wanted to do that, they should have done that and taken him back to Mississippi, Your Honor, for a detention hearing. However, it's unclear at that point, you know, what good that would have done, given that he was, not competent and their own expert had said that he couldn't appreciate the wrongfulness of his actions. So, I mean, I think it would have gone back to Mississippi. The criminal case against him would I'm not sure that he could go through that detention hearing process being incompetent the way he was, Your Honor. So,
well, he's still incompetent, and on this record, he's incompetent as of now.
That's correct. He's incompetent and he's unrestorable.
He's incompetent. He's unrestorable, and he's dangerous. So, what do you contemplate would happen to him if we rule in your favor? Is he going to go out and start shooting at planes again?
Your Honor, our position would be that if this court agrees with us that the government's certificate was untimely under United States versus WADA, our position is that, yes, he would go back to Mississippi and the government would have no further authority to confine him, Your Honor. However, we feel very certain that Mr. Curbo is no longer has lawful access to guns. So,
but they would have no further authority to confine him under this civil commitment proceeding, but they would still have authority under the pretrial detention, wouldn't they? Or would they not?
I'm not sure that they would, Judge Thacker, because he is incompetent and unrestorable. I mean, that you can't.
So your position is if he's incompetent,
I see what you're saying.
Released.
He does need to be released, Your Honor. Yes, and again,
that's what I say. Your position is he has to be released.
Yes, Your Honor. That is our position. He has to be released, and if he goes back,
and he had to have been released by as of December 2018, right?
That is our position, Your Honor. Yes.
Okay.
And does his lawyer in Mississippi agree with you, or do you know?
I have not been in contact with his lawyer in Mississippi, Your Honor.
Y'all not working together? You've got the same client. I mean, you're telling us what would happen to him in Mississippi. He represents him in Mississippi.
I believe the criminal case against him in Mississippi would have to be dismissed, Your Honor. And
That's
so
what I understand what you're saying. I asked you if your lawyer, his lawyer in Mississippi, agrees with you.
I do not.
You have consulted with him. I'm supposed to hear that.
I do not know, Judge King. I do not know that. But we feel very confident that
the challenge here today is, as I understand it, is to the certification that he's dangerous, made by the warden up at Butner and confirmed by Judge Britt. You haven't gotten around to that.
Yes, Your Honor, because we believe the certificate is untimely under WADA. WADA makes plain that the relatively tight window for civil commitment must be strictly construed, and the government must file its certificate before the period of commitment to the Attorney General's custody ends. WADA explains that a reasonable period of time allowed under 4241 D2B is, quote, only so long as to allow for reasonable, explainable administrative delays in the certification process. And Your Honors, the government has not come forward with any sort of reasonable explanation of the delays in this case. It would be as if, Your Honors, they're just pointing to standard procedures.
I thought they filed a declaration or affidavit of one of the officials, maybe more than one. I thought they did, and Judge Britt approved it. Unless I'm reading some different record.
They filed their certification, Your Honor, too late. It was untimely. It would be as if, Judge King, if I were coming to you after having filed a notice of appeal, 7 weeks too late.
Your position is these time designations are jurisdictional.
Yes, Your Honor, and under WADA.
I'm with you. They didn't rule on whether they were jurisdictional or not. You can't cite WADA for that, I don't think.
No, Your Honor, WADA did not reach that issue, and we've asked the court to.
So that's your position, though, that it's jurisdictional.
It's jurisdiction not only, but also under WADA makes clear that the reason that you can the Attorney General can only keep someone after the period of commitment expires. They have to file that certificate within a reasonable period of time. And here they did not file it within a reasonable period of time, Your Honor. They're pointing to standard procedures they follow in every
so the delay here was if we accept your proposition on the delay, is what, 49 days or 19 days?
So no matter what time period you look at, Judge King, whether you're looking at that, we believe.
Days, days.
No,
Which one do you say?
We believe it's 8 months, Your Honor.
Oh, okay. Okay.
But even if you go with just the 7 weeks, Your Honor, that's unreasonable in light of the circumstances of this case, where the government hasn't explained to you why it needed 7 weeks, for example, to do a dangerousness evaluation that 4246 doesn't contemplate until after.
Explain it to us. I don't think they had to explain it to us. They had to explain it to Judge Britt. He was the district judge that was handling the thing, and he said it was explained.
Your
he
Honor,
accepted the explanation.
Judge Britt simply said, well, because the delays here were shorter than the ones in WADA, that means it's automatically okay. And there were some delays here, but they were all reasonable. Judge Britt did not do any sort of analysis on that WADA requires it to do, Your Honor. We believe the reasonableness of that 4241 D2B time period is necessarily going to depend on two considerations, which is one, at what point did the government possess sufficient information to file a certificate, and two, what physical, behavioral, or administrative obstacles prevented the timely filing. And we don't believe that the government has provided any reasonable explanation for the delay, which means, Your Honors, that the delay in this case is necessarily going to be replicated in every case. Your Honors, I know my time has expired. I will save the rest of my time for rebuttal.
Thank you very much, Ms. Lyson.
Thank you.
Is it Ms. Petrie?
Petrie, Your Honor.
Is it Petrie? Petrie?
It is Petrie, Your Honor.
I apologize.
No problem at all.
Good to have you with us.
It's good to be here, Your Honor. Thank you.
Go right ahead.
Your Honor, Jenna Petrie for the United States of America, and may it please the court. Gary Curbo is a mentally ill and dangerous person, and he is subject to the provisions of 18 USC 4246. The government properly certified him, and the district court properly committed him as such. And this court should affirm the findings of the district court. There's been a lot of conversation so far about the time periods and when the time period for competency restoration under 4241D begins. And pursuant to this court's decision in United States versus Flannery, the time period under 4241D begins upon the person's arrival at the facility.
Is that
Here,
published opinion?
I believe that it is, Your Honors, and I can provide the citation if you need it.
No, I have it. I can find it.
And in that case, they determined that it is the arrival at the facility that starts that 4241D 4-month time period to begin. And in this case, Mr. Curbo did not arrive at FMC Butner until August 22nd, 2018. And that is the day that the evaluation under 4241D begins. And there's further
Wait,
support.
what about the July 26, 2018 time period when he was committed to the custody of the Attorney General?
July 26, 2018 is the day that the court ordered the commitment and found him not
Right.
competent and not restorable, but that's not the day that he arrived at the facility. And
But
pursuant to the
isn't
case,
that the day that the 4241D1 4-month period, at least the initial 4-month period, begins to run?
no, it is not, Your Honor. The period
Okay,
does
well,
not.
assume that I think that it is, and assume further that I think that the 4-month period lapsed in December, and that at the point that Dr. Riley completed her competency evaluation, December 19th, 2018, that Mr. Curbo should have been released. What would have happened at that point? Would he still have been subject to some sort of pretrial detention, or would he have just been released?
He would not have been released. His case was not dismissed. His criminal case out of Mississippi was still alive at that time. And so regardless of the fact that the evaluation wasn't completed until December 19th, 2018, he was not being unlawfully held. He was always in the custody of the Attorney General, either for commitment or for pretrial detention, pending those criminal charges. And it's important to note
so he would have gone back to Mississippi, assuming that, you know, I'm right about the December 19th, 2018. He would have gone back to Mississippi to go through the pretrial detention process, even though he wasn't competent to stand trial?
That's not necessarily required here, Your Honor. In Flannery, the court determined that
But it's what I'm asking. It's what I'm asking. So, so would he have gone back to Mississippi for detention proceedings, even if he was found not competent?
No, he would not in this case. And the reason for that is because Dr. Stribling Riley, the evaluator who worked on Mr. Curbo's case, didn't just opine that he was not competent and not restorable. She opined that there was a substantial probability that he could be restored in the foreseeable future. And the courts have said that the period, the 4241D 4-month period, can result in a respondent being held beyond the 4-month period as long as the facility makes the evaluation and conducts that within the required time. And that does not include the time to file the evaluation with the court. And so here, even if we assume that the evaluation period, that the 4241D period began in July and ended in November, he was still being lawfully held. And there was no problem then with the court, the criminal court, later on July 24th, 2019, ordering a second period of evaluation. Because there can be, and it's understood that there can be lapses between those two periods, because there has to be for administrative reasons. Courts often don't rule immediately. They don't automatically make those decisions. And that was addressed also in United States versus Flannery, as well as our sister circuits in the 9th and the 2nd Circuit.
The Flannery case, you told me that was published, correct?
I believe that it is, but I could be mistaken, Your Honor.
I'm looking at your brief at page 31 that says it's unpublished.
It
That,
says
that
unpublished.
could be correct. It is unpublished, Your Honor. I
It's
apologize.
not, it could be correct, it is correct.
That is correct, Your Honor. But it does refer, and I'll note for the court that it does refer to two cases from the Ninth Circuit and the Second Circuit, United States versus Villegas and United States versus Magasuba. And both of those cases, our sister circuits, rely on the same information and have come to the same determinations based on very similar facts as the facts that we're looking at here. And what those two courts have determined is that the time period has to start when the person arrives at the facility. And there's further support for that. So hospitalization in a suitable facility is what is required under 4241D. The language specifically says the Attorney General shall hospitalize the defendant for treatment in a suitable facility. But nowhere in Chapter 313 is that defined. But pursuant to United States versus Savage, there's no difference between legal custody in the Bureau of Prisons and legal custody in the Attorney General. And so we can look to 28 CFR 549.41. It's the regulatory definition of hospitalization in a suitable facility. And what that says is that hospitalization in a suitable facility is the Bureau's designation of a person to a facility, either a correctional institution or a medical referral center that provides the required care and treatment. If we consider that it has to be hospitalization in a suitable facility is only one that is designated by that definition. And there are only two in the Bureau of Prisons at the time that Mr. Curbo was committed to the custody of the Attorney General. So it was either Federal Medical Center Butner or United States Medical Center for Federal Prisoners, Springfield in Missouri. And it's the arrival at that facility that has to start the time period. Not only is it the way that the statute is written based on that break in the sentence, but also it's what makes the most sense here. A person is not receiving that hospitalization, that care and treatment and the competency restoration until they actually arrive at the facility. And so here, he did not arrive at the facility until August 22nd, 2018, which would mean that on December 19th, 2018, Dr. Stribling Riley completed a timely report finding him not competent and not restorable, but that there was a substantial probability that he could be restored in the foreseeable future. And then on January 24th, 2019, the criminal court down in Mississippi ordered a second period of restoration under 4241D2A. Now that would have expired on May 24th, 2019, and shortly thereafter, the BOP's evaluator opined that he was not competent and not restorable. And that is when the 4246 evaluation began. And there was a lot of discussion previously about the fact that the BOP, the evaluator, could have already made that determination, but that's simply just not true. And consistent with the declaration filed by Dr. Christina Lloyd in this case, you'll see that there is a lot of differences between a competency evaluation and a dangerousness evaluation about what that evaluator needs to look at. And so it did take some additional time, but that additional time is prescribed for in 4247B. It allows for a 30-day extension of time in which the evaluator for good cause shown can continue to evaluate under 4246. And that's exactly what happened here. Your Honors, the only time that passed in this case was 49 days from the time that the doctor opined that he was not restorable to competency and the date that he was certified as dangerous. And this court in Wada told the government that they must strive to certify a person in a time that eliminates or at least minimizes the time spent not restorable. And that is certainly what the government did every step of the way here. And this court also
you're
said
skipping over the first part. You're skipping over the 4 month time limit under 4241D1. You don't get to your reasonableness argument until you address the 4 month missed deadline.
And Your Honor, we don't think that there is any 4 month missed deadline here because it has to be the arrival at the facility that starts that timeline. And if we start the clock ticking on August 22nd, 2018, The evaluation completed on December 19th, 2018
What if you did start the clock ticking at July 26th, 2018?
Then the evaluation period would have ended, I believe, in late November, probably about November 26th, 2018. And there would have been a brief time where the evaluation, the report was not written. However, that doesn't mean that he wasn't evaluated within the time. So it would mean that right on August 22nd, he started to be evaluated, even though we're missing the time, the 27 days between July 26th and August 22nd. We started evaluating him, the BOP did, right when he got in the door. And the fact that the report came later does not mean that the evaluation was untimely. And there has to be some period between.
So how much later could the report come under your theory? If the 4-month period had passed and they didn't write the report for another year, was he still evaluated within the 4-month period?
Your Honor, I think under those facts, those would be very bad facts for the government, Your Honor. And I don't think that's what we're arguing here.
The statute sets a hard line at 4 months.
Your Honor, it sets a hard line of 4 months for the evaluation. But again, we have to look that there has to be some period of time for the evaluator to put all of the information he or she learned during the evaluation together and to put that down on paper for the court.
Where do we find that in the statute?
Your Honor, it's not in the statute, which is I think what creates this issue. But if the evaluator has 4 months to evaluate the person, if that's the day that the evaluation is subsequently due, then they could lose some time continuing to evaluate such that the person could be restored in that time lost writing the report. And so there has to be some reasonable middle ground here. And we believe that the report that was authored on December 19th, 2018 was close in time, it was appropriate, and it did not hold the respondent beyond the time period that he needed to be held. Because as long as the facility is making that,
it's not to exceed 4 months. And the sort of leeway you're talking about is already written into 4241D1. It says, shall hospitalize the defendant for such a reasonable period of time, and then it defines that reasonable period, the outlier of that reasonable period of time, not to exceed 4 months.
Yes, Your Honor, that's correct. But that, again, that's the time period that they are permitted to evaluate. So if the doctor had continued to evaluate him after the end of the evaluation period, certainly the government would have violated 4241D1. But that's not the facts here. The facts are simply that the report came, based on the government's belief, the report came on the day it was due, the last day of the evaluation period. And so there was no timeliness issue there. And even so, on August 28th, 2018, the warden, the acting warden of Butner, he sent a letter to the criminal court advising the court of Mr. Curbo's arrival at the facility on August 22nd. And he notified the court that the evaluation would be completed on December 19th, 2018, and that a report might follow would follow, but it might be within 14 working days of that date.
If that, based on that letter from the warden to the criminal judge in Mississippi, that takes it to January of next year, like 2019.
No, Your Honor, the warden's letter noted that
what's the calculation there? The additional 14 days, December 19th plus 14 days. Is that what you said?
Yes, it was plus 14 days. They did not calculate that time in the letter, and they also did not utilize that additional 14 days. But what it
calculated, but it carried over into January.
I believe that that's correct. It would have been very early January, Your Honor, right, that the report would have subsequently been filed if that were the case. And that letter, is sent in every single case by the warden at FMC Butner to advise the court of a person's arrival at the facility. And that way the court knows that
Was that sent to counsel in Mississippi? Do you know?
I believe that the parties were copied on that. It was sent electronically via email, and I believe both parties.
I understand, but what you say you believe? I ask you if it was sent to counsel. Can you say one way or another?
I cannot say one way or another, Your Honor. It is not in the record.
All right. Was it on the face of the letter?
I don't believe that it is on the face of the letter, Your Honor, but I will check while we continue. Yes, right. It does say at Joint Appendix page 66, it does say that both Mr. Wiggins, the Assistant United States Attorney, and Mr. Davis, the defense attorney, were copied on this transmission. And so
Mr. Davis is the attorney for this fellow in that criminal case.
That's correct, Your Honor. And so both parties.
That's what I'm getting at. That's exactly what I was trying to find out. Thank you.
You're welcome, Your Honor. Both parties and the court were notified that they intended to file a report within 14 working days of December 19th, 2018. Neither party nor the court indicated to the medical center at Butner that that was not the appropriate calculation of the 120-day period.
They don't need to do that. The statute does that. The statute doesn't say anything about evaluation or extra time to write the report. It says not to exceed 4 months.
That's correct, Your Honor. That is exactly what the statute says. And in this case, it did not exceed 4 months based on his arrival at the facility. And this letter from the warden simply notifies the court that the arrival came on August 22nd, 2018, and that the 4-month period would be calculated from that date. Now, certainly if that was not consistent with what the court wished, Butner would have been notified and they would have, accommodated the court's request. But because it's hospitalization that really starts that clock ticking, the hospitalization at the suitable facility, we believe that this was the proper way to handle the case and that there was no lapse during the 4241D period. And thus, he was properly in the custody of the Attorney General as a person who had been committed and hospitalized under 4241D at the time of certification, which does come within a reasonable period of time. There were administrative issues. There were also some physical and behavioral issues on the part of Mr. Curbo during the certification process under 4246. And those are all calculated based on United States versus WADA into that reasonableness time period. Now, respondent Mr. Curbo has argued that he has to be certified during the 4241D hospitalization period, but that's not what United States versus WADA says. It says that he has to be certified in a time that eliminates or at least minimizes his time spent as a not restorable person. And that's exactly what happened here. And reasonable time takes into account, it must take into account, according to WADA, the threat that the person poses to the community. And I think the courts have already, the judges have already noted.
You know that what you're speaking about in WADA is not addressing what I was asking about, right? The 4-month period under 4241.
Yes, correct, Your Honor. This is specifically
it's the reasonable time period.
That's correct, Your Honor. So this period that
it's not really analogous.
No, Your Honor, that both periods are important here. So the first period,
no, I
as I
agree
mentioned,
with that. I said analogous, not important. I agree it's important. I'm just saying that in my view, you're comparing apples to oranges. I agree this whole thing is very important.
Well, and I guess the point I'm trying to make, Your Honor, and I apologize if I'm not very clear, is that there are no issues.
Yeah, ma'am?
Yes, Your Honor.
I've got the certification that's on appeal here is the one of 17 July 2019. Is that not correct?
Yes, Your Honor, that's correct.
Right. And that was filed, it says on the face of it, pursuant to 4246A in two places. That's correct. Okay. I don't want to make sure I was looking at the right one. It's at Joint Appendix 9. Thank you.
That's correct, Your Honor. The reason that it says 4246A is because that's specifically the terms of the certification. But under 4246A, I apologize, Your Honors. I see that my time has expired. May I briefly answer your question and Judge Thacker's question and conclude?
Yeah, you can answer those questions.
I don't have a pending question.
You can answer my question, finish answering my question, and then you can answer any other questions you get, of course.
Thank you, Your Honor. Just to clarify that the face of the certificate, it says that he was certified under 4246A. 4246A includes 3 elements of people who can be certified under that particular statute. The reason that I mentioned that he was a person who had been committed under 4241D is because that is one of the classes of people who can be certified under 4246. And it is the government's belief that he was properly certified, he was properly in the custody of the Attorney General at the time of the certification, that this is not a subject matter jurisdiction issue, and that the findings of the district court should be affirmed in this case. And I thank Your Honors for your time.
And I got another question, though. Would you
Absolutely.
Right here? Is this on, for those issues that you just delineated, is it plain error review or harmless error review?
There are 2 issues on plain error review here, Your Honor. The first is the state placement issue that has already been addressed by this court in 2 unpublished cases, United States versus Foltz and United States versus Duncan. The second plain error issue before this court is the issue of the district court's findings and the sufficiency of those findings, which was not raised below. And so pursuant to United States versus Hire, they must meet the plain error standard. And they have not met that standard, and those findings on both the issue of the state placement and the sufficiency of the findings should be affirmed. If Your Honors have, I apologize.
Judge Thacker, you got any further questions?
No, thank you.
Judge Traxler, you got any questions?
Let me ask Ms. Petrie just one question. Has any judge or doctor ever found that it's safe to release Mr. Curbo to the general population?
No, Your Honor.
Okay, thank you. That was my only question from Ms. Petrie.
Thank you, Judge Traxler. Thank you, Ms. Petrie. We appreciate it. Ms.
Thank you, Your
Lightson?
Honors.
Yes. You still there, Ms. Lightson?
I'm right here, Your Honor.
You have some rebuttal time, and we'll be pleased to hear you. Thank you.
Thank you so much. I'd like to make very clear, I think this court should be worried about the government's position in this case, and its statutory interpretation is causing systemic delays in a process that Congress has said should be a very expedient one. That is, Congress specifically enacted these statutes to comply with Jackson v. Indiana's constitutional limitations against indefinite commitment. And the government, yes, Your Honor. I'm sorry. I thought Judge Thacker, do you have a question?
No, go ahead.
I'm so sorry. So first of all, this notion, Your Honor, that the only suitable facility would be a BOP facility. So basically, in the government's view, they have to send everyone to either Butner or Springfield, which of course results in the very foreseeable problem of huge waiting lists at Butner and at Springfield. Of course, the statutes themselves, Your Honor, expressly authorize the Attorney General to place people for evaluation in practically any other place. They can contract with any state, any county, any private facility to perform these evaluations. And also, notably, Congress directs that these really should be taking place in a facility closest to the court. But instead, of course, the government's just sending everyone to Butner and Springfield. The government's own expert admits that there's a 13 to 15 week waiting list.
That's where they have the expertise. That's what she explained. That's where they have the expertise. That's been that way for years and years and years and years. Springfield Hospital and Butner facility. That's where they do this stuff.
Yes, Your Honor, but they only have 4
months. And they're overworked and overextended. I've been to both of them, ma'am, as a lawyer. And I've observed some of the stuff that they do.
So again, Your Honor, we just respectfully disagree that the 4-month commitment period starts at the arrival time at the designated facility. It starts with the district court's order. And that's what this court indicated in WADA. Judge Thacker, you wrote a very plain, very easy to follow timeline in WADA, indicating that
Apparently not.
indicating that the 4-month commitment period starts when the district court commits that person. Otherwise, we have people just sitting around in transit for months and months until the government finally gets around to actually transporting these people. And that's
so if they kept them in transit for 4 months, they'd have to release them. In your theory, this fellow be down in Mississippi shooting the military planes again.
So, Your Honor, what I think needs to happen is what Congress has indicated should happen is that these proceedings take place expeditiously, because again, we're talking about incompetent people who are
the important thing
must
is
be
that
presumed innocent.
The most important thing is that these examinations be conducted properly. There's a major public safety issues involved in each of them. They need to be conducted properly for the public interest and for the interest of the individual.
And Your Honor, we have no quarrel with that. And the 4-month commitment period is by far the longest time in the mental health statute. It gives the government plenty of time to decide whether or not this person can be treated. And it's also the government's duty to protect the public, for sure. So they need to make that decision whether or not that person is coming up on release before we release this individual, because we don't have any authority to hold them longer than 4 months. We need to decide whether the only way to hold that person is to file the 4246 certificate, which again is just a minimal burden on the government, Your Honor. It's, you only have to attest to 3 facts and 3 facts only. Does this person have a mental illness? Because of this mental illness, do they pose a risk? And 3, is there state placement available? Nowhere do you have to do a dangerousness evaluation. That comes only after the certification. So all of this time, and I'd like to go back.
And as your colleague there said, the lady from the government, that's a complicated issue. More complicated. The dangerous evaluation I'm talking about.
And it comes, Your Honor, under 4246B. That comes after the certificate is filed.
And the doctor that was designated to evaluate this gentleman for himself, his own doctor agreed with the government doctors. He's incompetent and he's dangerous.
Yes, Your Honor. And they knew that well before the commitment period expired. So if they wanted to keep him past that 4-month deadline, they needed to file that 4246 certificate to keep him there, or get a substantial probability finding from the district court, which they did not do. And so, Your Honors, they had plenty of information. They could have filed their 4246 certificate back in November 26, 2018. It's not a high burden. It would be as if, Judge King, I were coming to you after having filed a notice of appeal 7 weeks too late, and you're saying, Ms. Leiston,
it's not comparable to a notice of appeal. Notices of appeal are jurisdictional. These timelines are not jurisdictional.
We respectfully disagree with that, Your Honor, but we don't think that in any event, this court in Timms said that those filed the requirements for filing that certificate are extremely minimal. It's a very low burden on the government to just file the certificate, then that stays the person's release. The person is stayed, and then the government has plenty of time to do that dangerousness evaluation, but they're doing so under the watchful eye of the court, and not simply sort of whenever we get around to it, we want an extra, 30 days, 45 days. It's simply not reasonable, Your Honor. And so for those reasons, Your Honor, and for the reasons in our brief, we would ask this court to vacate the order of civil commitment and remand this case to the district court for dismissal of the certificate. Thank you, Your Honors.
Thank you. Thank you very much, and thank both of you for your arguments. We appreciate it very much. If we were in Richmond, like we hope to be this fall, we would, at this point, come down from the bench and greet counsel and tell you personally that you've done a good job. We can't do that today. So we'll take this case under advisement, and Madam Clerk, you may call the next case.
Thank you, Judge. The next case is 20-1584, Randall Yawn versus Dorchester County.
And Mr. Bremer, are you out there?
Yes, Your Honor.
Good to have you with us.
Thank you. May it please the court. Thank you, Your Honor. May it please the court, I am David Bremer for the appellants Mitch Yawn and Juanita Stanley. Your Honors, Yawn and Stanley's bees and equipment are non-nuisance, non-dangerous property interests untainted by any law enforcement process. There's no blanket police power exception to a physical taking of this type of legitimate property interest, and the killing of the bees is therefore subject to the same fact-based comprehensive analysis as any other physical taking of private property. But the district court ruling wrongly gave the county a categorical police power pass around the takings clause, and in so doing, it short-circuited the normal takings inquiry in this case while immunizing the government from the takings clause in a wide array of future cases, as long as the government is smart enough to figure out how to ground a taking in the police power, it's immunized under this lower court ruling. I want to emphasize again that the property interests here are critical to understanding the scope of the police power. These bees, this is a licensed business. These bees and equipment are personal property protected by the takings clause. They've never been a nuisance. They're not harmful to anybody, and they cannot be subject to a police power exception. Rather, the taking analysis must include all the circumstances, including the burden on Mitch Yawn and Juanita Stanley of this police power-based taking. And the problem is not for this court, the problem for this court is not to decide whether a taking has actually occurred in this case. Is to allow Mitch Yawn and Juanita Stanley to have their day in court on the takings analysis so that they can present the entire legal framework and inquiry to a court rather than having the door slammed shut based simply on the words police power.
Mr. Bremer, this is Judge Thacker. Didn't the Supreme Court recognize the existence of a police power exemption in Lucas in circumstances closely analogous to this, at least that there was a grave threat to lives or property of others?
No, Your Honor, I don't believe so. In fact, what the Supreme Court did in Lucas is say that if your property interest is a nuisance, then the government may have a defense to a takings claim. But it actually rejected the broader proposition that the district court adopted, that the police power itself automatically immunizes the government. It rejected that proposition and said, no, the police power, just because you're trying to protect public health, safety, welfare, morals, that doesn't mean you can go around taking and destroying private property. You have to go through a takings analysis. And if you can prove that the property itself is a nuisance, then maybe you have a defense. But here, of course, there's no claim that these bees or this business is a nuisance. It's a licensed business. And I would point, Your Honor, again, in answer to your question, back to the Pennsylvania Cole Mahone case in 1922, which is the quintessential and critical police power takings case, in which there in Mahone, the government was trying to stop coal mining under the land because they didn't want the land to fall in and hurt people living on a house on top of the land. I mean, it's a quintessential police power action. And the Supreme Court said in Mahone, if it goes too far, if the police power action goes too far, it can still be a taking. So there's more to the analysis than just, well, it's a health or safety action.
And does it matter to your analysis whether the death of the bees was incidental versus intended or foreseeable?
Well, Your Honor, that the foreseeability may be a factor.
I mean, I guess my point is that the government here made efforts to make sure that that people knew that this spraying was going to occur. They put the public notice in. They even the person flying the plane even I guess omitted direct spray at this property. So it wasn't intentional. Does that matter? I mean, in fact, they took steps to make sure they didn't cause harm, undue harm.
Right, I understand your question, Your Honor, and let me try and answer it. In the Ridgeline case from the Federal Circuit, which dealt with the difference between takings and torts, this is the leading case on this issue of a taking or tort. The Federal Circuit held that
maybe qualified immunity kicks in here somewhere.
Excuse me, Your Honor?
I said perhaps qualified immunity comes in here if they're acting in good faith, because that sort of flows from the point I take from Judge Thacker's question.
Right, and if I could finish my answer, I'm almost there. When a government action is, when a property loss is the direct, natural, or probable result of an authorized activity, it is a taking and not a tort. And the problem here is that applies here. This is the direct, natural, probable result. But the problem here really is that we never got to these issues because the door was closed on us with the words police power. And I understand that the government, the county, wants to argue that there was foreseeability or it's not intended. And they could argue that, but we didn't get to argue that because the court held that simply by virtue of the purpose of this action for health and safety, there is no further analysis. You property owner lose, and there's nothing you can do about it. And that is a dramatic ruling that contradicts the Supreme Court's 100 years of takings precedent, which, by the way, would not exist if this police power ruling of the district court was the actual correct rule. It's not. The government.
Mr. Bremer, this is Judge Traxler. You might have not have argued this in the district court, but we have the authority to affirm for any reason appearing in the record. So you can argue right now as to whether or not there can be a taking where the injury is unintentional. And I need to hear you on that subject as Judge Thacker asked you to, please.
Thank you, Your Honor. And I'm going to answer it. Ridgeline 346 F3rd 1346, the leading case in the Federal Circuit on the question that you're asking, says this: it's a taking and not a tort if the property loss is the direct, natural, or probable result of an authorized activity. That is what happened here. This bee kill was the direct, natural, probable result of an authorized spray. Therefore, it's not a tort, it's not incidental, it is a taking. That's the Ridgeline case. In Arkansas Game and Fish, Your Honor, the court indicated that if the property loss is foreseeable, it is a taking. Here, this property loss, the killing of the bees and the destruction of their business was entirely foreseeable. So I understand your question, but we have a good and correct answer to that. This is a taking and not an incidental tort-like loss. And therefore, we should be allowed to prove the elements of a takings claim and not have the analysis short-circuit because of the health and safety and welfare purpose. Hopefully that answers your question on that issue. I would note, even, Your Honor, even the COVID cases, that property owners get a more comprehensive analysis of their takings claim than what we got below. The courts in COVID cases don't stop with, well, we're trying to protect public health. They look at the burden on the property owner. They look at the loss of use and enjoyment, the invasion, and a full analysis. And so we never really got that, and that's just simply not consistent with the Supreme Court takings jurisprudence. Yes, Judge Decker.
Oh, I'm sorry, I don't have anything.
I'm sorry, I thought I saw the light come on. We know that in this case, Your Honors, the county was aware that this pesticide was highly toxic to bees. They were also aware that it could kill them. That's why they tried to give notice and failed to give notice. This wasn't a random, unauthorized action. This was a purposeful action to spray over private property. And that—
You're saying it was purposeful to kill the bees? You don't mean that.
I said—
You don't mean that.
That's not what I—
They were trying to kill mosquitoes.
Your Honor, I didn't mean to say that they were intentionally setting out to kill bees. I said they intentionally set out to spray pesticide over property that had bees, knowing that this pesticide kills bees and would likely harm any bees it touched. That's why they gave notice. So it was foreseeable that this would happen. I didn't say it was, they did it on, I said it's foreseeable. That's different.
You said they did it purposefully. It sounds like it's a negligence case to me.
Okay, I'm sorry for the misunderstanding. I say their action was purposeful. Their action was purposeful. The result was foreseeable. And that makes this a taking and not a tort. So what we're asking for is a chance to address these issues. If the government believes it has some kind of defense, then we should be allowed to address that below, but we need to be able to make our claims too. And that's this property is destroyed. There's a lot of damage and there's no remedy right now for the—
Don't you have state law claims in this case?
Yes, we do, Your Honor. We have state law claims.
You said there's no other remedy. You just now said there's no other remedy, and you got other claims. Okay.
There's no other remedy for this takings except just compensation. So we haven't been— I was going to finish my sentence. So we haven't been allowed to prove our entitlement to just compensation because the analysis was short-circuited under this police power ruling. If the lower court's police power ruling is correct and you have to act under the eminent domain power to trigger a takings analysis, there would be no takings clause jurisprudence because every Supreme Court takings decision in the last 100 years has dealt with a police power action that's subject to a comprehensive takings analysis, including Arkansas Game and Fish, which was a flooding, and the government argued there it was incidental, it wasn't, they didn't mean it, and the court applied the standard comprehensive fact-based analysis, and that's what we're asking for, rather than a blanket per se defense. Let us prove our case. And if there's no more questions, I will reserve the remaining time for rebuttal, Your Honors.
Thank you very much, Mr. Bremer. Ms. Maybank?
Thank you, Your Honor. May it please the court. My name is Amanda Maybank, and I represent Dorchester County in this matter. The district court properly granted summary judgment on the federal constitutional taking claims in this case and should be affirmed. Contrary to the plaintiff's position, this case, the district court's order does not create a blanket police power exception to the takings liability, and the county has never advocated as such. In fact, in our motion for summary judgment, our position has been, one, we had to address that what authority the county was acting under, because the plaintiffs in their complaint alleged that the spray itself was unauthorized. And in fact, they even sought an injunction seeking the county from being able to conduct any further mosquito sprays. So we had to justify in response to the plaintiff's pleadings under which authority we acted, and that was the police power. The plaintiff's theory changed slightly and was alleged in there, which seemingly alleged an eminent domain theory, which was not applicable in this case, and the district court properly addressed that authority. Our position has also always been that this was not a foreseeable or an intended consequence of the spray. The district court, in her order, even says that the defendant argues it exercised its police power to protect the public from the mosquitoes and the Zika virus that they carry, defendant further submits that it did not act affirmatively to take the bees for public use. And that's the key in this case. There wasn't the law. First of all, there's been no determination that the bees died because a result of the spray. As Your Honors correctly noted, the county placed several notices in the local media outlets. The county had instructed the actual operator of the airplane who was conducting the spray to turn off the spray before it reached the beekeepers that were in the spray area. And the other beekeeper in the area did not suffer any harm to their bees as a result of the spray. So it's not, contrary to Mr. Bremer's argument that this was direct and foreseeable, the simple fact that the other beekeeper in this area, a fact which the plaintiffs admit to in their response to our summary judgment motion, is evidence that this was not a foreseeable or intended consequence. And the county did not know that there was any problem with the Yawn and Stanley's bees until after the fact, when the spray had occurred. The district court properly utilized the guidance that was provided in the Supreme Court cases, which say that a takings inquiry is a fact specific and a case by case basis inquiry, unless it is one of the two bright line cases that have been recognized, such as a permanent taking, as in Loretto, or as at Lucas, where a regulation permanently deprives a property owner of all its economic value. This was not one of those cases. She took into consideration that we acted under the authority of the police power, and then she also took into the fact that we did the order notes, that we placed the notices, that we the Clemson report, which is the body that investigates these types of cases that relate to the use of pesticides and chemicals, came out and found that the spray was conducted pursuant to law. They found no violations. That Clemson report also could not conclude one way or the other if the spray contributed to the bee loss that the plaintiffs claim. The cases in such as Loretto, or excuse me, Lech, that is cited by the district court order, that in itself is, while she relies on that for the police to describe the police power, even that in itself is different than the facts of the case that we have here, in the fact that the Lech's house was damaged by the police, in that the police action the action taken by the police was the direct and foreseeable consequence of the fact that there was a criminal inside. In this case, the plaintiffs were just the plaintiff's property was just one of several that was in the area of this mosquito spray that was required because of the reported Zika cases, and was not a case in which the Dorchester County came to the plaintiffs and said, we have to spray your property and get rid of your bees because of a harm that they were causing. That's not the situation. This is just an unforeseen, unintended consequence, which has been recognized by the Supreme Court in Arkansas Game and Fish and in San Giannetti, that in a takings analysis, it is relevant the degree to which the invasion is intended or is foreseeable result as a result of the authorized government action. I'd say in my brief, I do cite to the Columbia Basin Orchard case, which I found to be the most analogous to the case at hand, in the fact that the government, there was an orchard that was at the base of a spring, and it used that spring to irrigate its trees. In the vicinity of that spring, the government was making preparations to build a dam and encountered water and was siphoning off water. And the plaintiffs alleged that excess water combined with the excess flooding or excess rain and winter runoff caused them to lose their orchard trees because the spring became contaminated with that excess rain. And in that case, the court found that was a unintended consequence and not a foreseeable result to the government's dam preparations. And it recognized that, if anything, the remedy for the plaintiff in that case would be in tort, not in a constitutional taking. And I think that brings us to the real issue here. The real issue is not whether we have the authority to conduct the spray. It's the plaintiffs are complaining about a specific action of the fact that Mr. Gaskins, who is the head of mosquito abatement for Dorchester County, admitted, and as the district court found, he mistakenly did not call Mr. Yawn to tell him about the spray. That's the action that's being complained of in this case. And that at best, the county does not admit that there was any negligence, but at best, that's what the cause of action that the plaintiffs would have against the county would be, a claim of negligence. There's not a constitutional taking. And the Supreme Court I don't believe it was the Supreme Court, but the district court has recognized that there's never been a case in which the Supreme Court has held that a mistake or an accident rose to the level of a constitutional taking.
Ms. Maybank, this is Judge
Yes,
Traxler. Are you familiar with the case that Mr. Bremer mentioned in response to my question about whether or not a taking claim could be based on an unintentional act?
The Ridgeline case?
Are you familiar with that case?
Yes, sir.
Okay, and would you make a specific response to that, please?
Well, in the Ridgeline case, this was also a flooding case. Sorry, Your Honor, one moment. Oh, yes, sir. In the Ridgeline case, the plaintiffs alleged that the storm drainage from a postal facility that was built by the government caused flooding and that it onto their property, and that it constituted a taking. I'm sorry, Your Honor. I'm trying to remember what the holding was in this case. Let's see here. I'm sorry, Your Honor. I had the case here and I had it in my notes, but I didn't have the exact, a lot of information written down about it. Yes.
Well, don't let that slow you down. You can go on to other parts of your argument if you want to.
So the court had to determine whether or not that the increased runoff was a predictable result of the government's action. And in that case, I think the court went on to hold that it was not intended, in the fact that they had engineers that had studied the question before it was built and had prepared the plans. And I believe, Your Honor, that the holding was that if the engineers had predicted that was going to be a case, and that the canal would be, or the flooding would have occurred, that would have been a factor in the case.
That's okay. You can stop.
All right, I'm sorry, Your Honor. I got a little bit distracted by that, but the court did say that they had a look at what steps the government had taken to address the water runoff and the water retention, and whether or not that would have been foreseeable or not. And as the court has already recognized in this case, we did take steps to notify the public about the spray. We did take steps to minimize the amount of chemical that was sprayed in the area over the known beekeeper locations. And in this case, that Jan and Stanley were the only beekeepers that suffered allegedly any result. And again, we don't have a determination, as the Clemson report was unable to determine one way or another whether or not the spray actually did cause the bee loss that the Jans alleged that they sustained. If there are no other questions, I will conclude that the district court should be affirmed. The district court's order does not create a blanket exception. The district court, using the guidance from Arkansas Game and Fish and San Gianetti that required a fact specific to the case analysis, determined that the county had authority to act pursuant to the police power, and that the loss of the bees was not a direct or foreseeable result of the spray, and that it was incidental and unintentional. And as the court has recognized, this deals only with the federal constitutional claim, in that plaintiffs still have a remedy in tort should they choose to proceed. And if there are no other questions, I know I have some more time left, but
you don't have to use all your time at all. When you're finished, you know when you're finished.
All right. Well, if there are no other questions, then I will allow Mr. Bremer his rebuttal.
Thank you very much, Ms. Maybank. We appreciate it.
Thank you, Your Honor.
Mr. Bremer?
Yes, Your Honor. Thank you. Let's deal with this issue of intention. Hello.
Go ahead.
Let's deal with the issue of intentionality in takings claims for one moment. It has never been the case that the government must intend to take property to give rise to a takings claim. In Lucas, in Mahone, in Nolan, in Palazzolo, the government wasn't intending to take private property. It was regulating property, and a taking resulted, or a claim was made that a taking resulted from its intentional act, not from its intent to take. So let's get that aside for the moment. Intent is not an element. What is an element, though, a potential element, is what my co-counsel concedes, whether the action was foreseeable or predictable. That is a disputed fact question. The district court did not resolve that question. As I mentioned before, we didn't ever get to that because the language of the district court, the arguments were all about whether the police power purpose of the county itself absolves the county of the need to get into these other factors like foreseeability or predictability, and we never got there. So the Ridgeline case that our counsel was referring to, the leading case on this incidental or direct, it's been followed many times. It says this: if the property loss is the direct, natural, probable result of an authorized activity, which is a fact question, I would think, that the court didn't reach below, then it's a taking. So what needs to happen here is that this case needs to be remanded so that this fact question about predictability of foreseeability can be addressed, and the other elements of a takings claim can be addressed as well. And the county will have a chance to try and prove that this wasn't foreseeable. I don't see how they can do that given the notice they tried to give and the labeling of the pesticide. And then I don't see how they can do it, but they can try. And we can prove the opposite, and we could also prove our damages and the effect and the destruction of the business and the existence of the license, all the things that didn't happen below that still need to happen. So if there's no more questions, I will end that. Ridgeline should resolve this case in favor of remand.
Well, thank you, Mr. Bremer. We appreciate it very much, with you and Ms. Baybank. I'm going to, Madam Clerk, Judge Traxler, Judge Thacker, I'm going to ask for about a 5-minute break if there's no objection.
Of course not.
Is that all right, Judge Thacker?
Certainly.
Okay. Let's stand easy for a few minutes, Madam Clerk.
This honorable court will take a brief recess.
Attorneys, I'm going to move you in.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Our next case is 20-1655, North Carolina Department of Environmental Quality versus Federal Energy Regulatory Commission.
Thank you, Madam Clerk. We have a couple of lawyers here on the side of the appellants. Mr. Moore, you first up.
Yes, Your Honor. Thank you, Judge King. May it please the court?
Who do you represent, Mr. Moore?
Yes, sir. I represent PK Ventures, which is the owner of this dam that's at subject issued in this case.
All right, sir. Good to have you with us.
Thank you, sir.
And what is it that you want? Tell me that.
We would like you to void this license issued by FERC, and that would dispose of this fight between the federal government and the state here.
Okay, sir.
It please the court?
Go right ahead.
I'd like to take you to the Haw River in Bynum, North Carolina. That's about 20 minutes to the west of Raleigh, where PK Ventures, my client, owns a dam. It's a small dam. The river's small. It's probably about 20% the size of the James River. And the dam there used to, many years ago, 10 years ago, last time it generated was 2010. It produced about 600 kilowatts, which would generally provide power to about 400 to 500 homes. Although, if you know something about hydropower, it can't run 24/7. So, talking about a very small project. And my client PK Ventures bought this in 1986, and they're asking this court to please void the license that was issued by FERC in September 2020. Because if you don't void the license, then my client's going to lose this dam. They're going to lose the dam. They're going to lose the water rights. They'll lose the land around it, because FERC has illegally decided to issue a license to a third party, McMahon Hydro. And interestingly and curiously, they're not here today, Your Honor. And in fact, they didn't get involved in any of the proceedings below, and they didn't come here in the Fourth Circuit to explain to you what was going on.
Who's not here, you say?
McMahon Hydro, they're the company that FERC has issued the license for our dam.
They're the ones that they want to run you out and put them in, right?
They want to run us out, yes, sir. And there's an ability,
That's
if
right.
they get the license, they can condemn that property. They can condemn the land, the water, the hydropower, the dam, the whole thing. And we don't want that to happen. We have other plans for it. The reason and the basis is that there's no jurisdiction under the federal.
Excuse me, this is Judge Thacker. You're faulting them for not being here, but did your client submit its own application?
Yes, Your Honor, we did. Yeah, we did in 2015, Your Honor. Or no, that was actually 2013.
Where is that in the record?
Well, I don't think that was the index. If you're involved with a FERC proceeding, they're pretty big. I'm not sure that notice of intent is what it's called, is in the record, Your Honor, but I can.
Okay, so for our purposes, it's you didn't file for an application because I can't find it anywhere in this record.
Well, the reason that you know that we did is that we were granted intervention status below by virtue of the fact that we're the owner of it, and we had filed previous documents and a notice of intent. It's actually referenced in some of the court orders, Your Honor. Not the court orders, the FERC orders below. I've got a very short.
Okay, go ahead.
Yeah, I've got a very short period of time. Put very simply, under the Federal Power Act, on this water body, unless the project were to produce power, there is absolutely no authorization. And this comes from the Interstate Commerce Clause, Section 1, Article 1, Section 8. This court itself, in a similar case, Nantahala Power and Light, held that the test of whether or not the Interstate Commerce Clause is triggered under the Federal Power Act is whether there's a presently discernible effect on commerce. That's at page 286, 384, Fed 2nd 206. What FERC says is that the reason they have jurisdiction is that this project will affect commerce. And that runs afoul of Nantahala Power and Light. It also runs afoul of the Supreme Court's decision in Federal Power Commission versus Union Electric, where they said that it's beyond Congress's power to issue a license on a non-navigable stream that doesn't generate power. And in fact, we've cited many cases where a facility didn't generate power into interstate commerce, and FERC decided on its own that it didn't need a license. So, concluding my time, It would be an advisory opinion to rule on that government-to-government fight that you're about to hear about under Section 401. So we'd like to invite the court to please rule on the jurisdictional issue, and the rest would be advisory. Thank you, Your Honors.
Thank you, Mr. Moore. We appreciate it. And Ms. Spiller?
Yes, good afternoon, and may it please the court. Asher Spiller for the North Carolina Department of Environmental Quality. Under Section 401 of the Clean Water Act, a state waives its authority to issue a water quality certification if the state fails or refuses to act on a certification request within 1 year of receipt of such request. In this case, FERC erred in determining that North Carolina waived its certification authority for the Bynum hydroelectric project because North Carolina did not fail or refuse to act on McMahon Hydro's certification request within 1 year. In fact, DEQ issued McMahon Hydro a 401 certification with conditions necessary to protect North Carolina's Haw River, and it did so well within 1 year of receipt of McMahon Hydro's February 2019 request. The fact that McMahon submitted prior requests and made the choice to withdraw those requests has no bearing on the waiver analysis required under the statute. I'd like to make 3 main points today. First, the Commission's waiver criteria cannot be reconciled with the text.
Mr. Spiller, I can't hear you very well. I don't know what the issue is, but.
I'm sorry, Your Honor. Can you hear me now?
Are you too close to the speaker or too far from the speaker, maybe? Go ahead.
I apologize. Can you hear me now, Your Honor?
I think that's better. Yeah.
Okay. So again, 3 points today. The first is that the Commission's waiver criteria cannot be reconciled with the text of the Act. Second, the Commission's waiver determination is not compelled by the DC Circuit's decision in Hoopa Valley. And finally, the Commission's determination is not supported by substantial evidence in the record, which is an independent basis for vacating the waiver determination. Courts have consistently held that Section 401 establishes a bright line for determining when a waiver occurs. And this bright line is crucial not only because it ensures timely action by the states, which it certainly does, but because it gives states clear guidance on when their statutory authority to protect their surface waters is waived. And these waiver decisions are no small matter. They can have significant consequences for states and for the environment. And because licenses issued by the Commission, like this one for McMahon Hydro, last for decades, in this case, 40 years. And once the Commission declares that a waiver has occurred, the activity moves forward without the conditions that the state would impose to protect its surface waters. The Commission's ad hoc waiver test in this case departs from the bright line that Congress established because unlike the statutory text, the Commission's test does not require a failure or refusal to act on the part of the state. Under the Commission's test, if an applicant makes the choice to withdraw and resubmit its certification request, the state is deemed to have waived its certification authority if 2 conditions are met, conditions which appear nowhere in the statute. The first condition is that there was some level of coordination between the applicant and the state that the Commission decides is sufficient. And the second is that the applicant's new application is substantially unchanged in some sense. Now, beginning with the concept of coordination, it's very difficult when reading the Commission's brief in this case to pin down what the Commission really means by sufficient coordination. And looking at the waiver determinations in this case, it's easy to see that this concept is not just poorly defined, but it's completely ungrounded in the statutory text. The Commission found 2 waivers in this case. The first was in 2018 when McMahon Hydro contacted the agency to request information on how to withdraw and resubmit its application. And the agency simply responded, identifying the paperwork that McMahon Hydro would need to submit. The second was in 2019 when McMahon Hydro again communicated to the agency that he desired to withdraw and resubmit his application. And a staff engineer sent an email simply reminding McMahon Hydro of the February 2019 statutory deadline. In both of these circumstances, the choice of whether to withdraw and resubmit the 401 application rested entirely with McMahon Hydro. If McMahon Hydro had not withdrawn its application, DEQ certainly would have acted on it. Nonetheless, in both of these situations, the Commission apparently believed that DEQ's mere communication with McMahon Hydro regarding its voluntary choice to withdraw gave rise to a waiver. The Commission simply does not explain how DEQ's communication with the applicant regarding the applicant's decision to withdraw constituted a failure or refusal to act, which is what the statute requires. And the Commission's departure from the bright line that Congress established has also led to blatantly inconsistent decision-making. In cases like Village of Morrisville and KEI Power, which the Commission issued just months after DEQ filed its opening brief in this case, the Commission reached opposite conclusions on facts that are materially indistinguishable. In those cases, the applicants withdrew and resubmitted their certification requests to restart the statutory clock and to avoid receiving decisions from the states in those cases that they viewed as unfavorable. The Commission found no waiver occurred in those cases, even though those withdrawals were preceded by communication.
Mr. Spiller, say when you refer to the Commission, you're talking about FERC, right?
Yes, Your Honor.
Yeah, all right.
And the Commission found, I'm sorry, Your Honor, is there another question?
No.
Okay.
I'm sorry.
The Commission found no waiver in those cases, even though those withdrawals were preceded by communications from the states instructing the applicants regarding the withdrawal and resubmission process, communications that were very similar to the ones that occurred in this case. And the notion that a waiver of a state certification authority could turn on FERC's parsing of these email exchanges cannot be what Congress intended in establishing a bright line under Section 401. In these cases, the Commission stated that the states should not be blamed when an applicant decides that withdrawing and resubmitting its application to avoid an unfavorable action by the state is in its interests. And the Commission offers no reasonable basis and can offer no reasonable basis for reaching a different conclusion in this case than it reached in those cases. The Commission's second criterion, other than the coordination criterion, is that the resubmitted application is substantially unchanged in some sense. And that criterion is also unsupported by the statute. There's 2 points I want to make on this issue. The first is that when an applicant withdraws its certification request, there's simply no more request for the state to act on. And at that point, the extent to which any new request from the applicant is similar to one that has been withdrawn is simply irrelevant under the statute. The statute provides that the waiver period runs from receipt of the request that's actually pending before the agency, regardless of whether similar requests have been previously withdrawn. The second point I want to make is that, like the coordination criterion that the Commission has identified, this one, the substantially unchanged idea, it's difficult to understand what the Commission means by this concept as well. We certainly don't dispute that in this case, when McMahon Hydro submitted his new certification requests, he didn't append new information at that precise moment, but it is certainly not the case that these requests were no different from the requests that were submitted a year prior. And the Commission knows this. The 2018 requests, for example, had a draft water quality monitoring plan included with it that was not included in the 2017 request. The 2019 request had an environmental assessment and a revised water quality monitoring plan that were not included in the 2018 request. So this isn't a case like Hoopa Valley, for instance, where you had a complete application that gets withdrawn and resubmitted with no changes in the interim. And that moves me to my next point, Your Honors, which is that the Commission's decision in this case is in no way compelled by the DC Circuit's decision in Hoopa Valley. The Commission has to ignore large portions of the DC Circuit's reasoning in that case to make its argument. As the DC Circuit expressly pointed out in Hoopa Valley, that case involved what the court called deliberate and contractual idleness. The parties entered into a contract that was binding on the state and the applicants that required the states to put their review of the 401 application in abeyance and required the applicant to repeatedly withdraw and resubmit identical applications for the express purpose of avoiding a waiver. Now, in finding that the state's actions constituted a failure or refusal to act within the meaning of Section 401, the court expressly pointed to the existence of a contract. In this case, there was no agreement, there was written or otherwise, between DEQ and McMahon, and the Commission does not appear to argue that there was in its brief. Also in Hoopa Valley, the court pointed to the fact that the states and the applicant did nothing to advance the 401 application for more than a decade. In this case, the record shows that DEQ worked diligently with McMahon Hydro to identify the information that the agency would need to issue a certification. And then lastly, the arrangement in Hoopa Valley had the effect of shutting the third parties out of the process, which the court stated was a relevant fact. And not only are there no third parties seeking this waiver determination here, the applicant, McMahon Hydro, didn't even ask for it. The only party seeking to invalidate DEQ's certification in this case is FERC. Now, in the unlikely event that the court believes Hoopa Valley compels the commission's determination, the court should decline to follow that decision. Now, I want to turn to my final point. I see I'm running out of time. The commission's waiver determination should also be vacated for the independent reason that it is unsupported by substantial evidence. In its waiver decision, the commission made two critical findings. The first was that when McMahon withdrew and resubmitted its request in 2019, it was at the direction or behest of DEQ. The second was that the 2018 withdrawal was not, quote, unilateral, a unilateral action by the applicant. And both of those findings are incorrect and lack support in the record. The commission does not even defend in its brief its initial finding that DEQ directed McMahon Hydro's actions. And I see that I'm out of time. So if there's no questions, I'll reserve the remainder of my time for rebuttal.
Yeah, you saved some time, Mr. Spiller. We appreciate it. Ms. Chu?
Yes, Your Honor. Thank you for having us here today. May it please the court, Susanna Chu for the Federal Energy Regulatory Commission.
Yes, ma'am. Good to have you with us. Thank
you. If it's all right with the court, I'd like to start with the arguments of North Carolina DEQ. As Mr. Spiller correctly notes, the statute is a bright line rule. The commission here is doing the best it can to apply this express statutory directive as interpreted by the courts of appeals. The decision was compelled by both the language of the statute itself and the decisions in Hoopa Valley and also in the New York State DEQ case, which was a Second Circuit 2018 decision. Here, the commission's determination on these two prongs that the withdrawals and resubmissions were not, they weren't voluntary withdrawals and were not new applications that would restart the one-year clock. These determinations come straight out of the statute itself and also as interpreted by the case law. The statute says that a state waives certification authority by failing or refusing to act on a request for certification within 1 year after receipt of such request. We know the 1 year period runs from when a state receives an application and a state cannot deem an application incomplete to give itself more time. That's both City of Fredericksburg and the New York State DEC case, which are both cited in our brief. Now, Hoopa Valley sheds light on when a withdrawal and resubmission of an application may actually be a state failure to act. And that's where the coordination and the question of whether there's a new application come in.
Ms. Chu, this is Judge Traxler. Let me ask you a question. Does the commission attribute some nefarious purpose to these withdrawal and removals of the request between the North Carolina and the prospective dam owner?
No, Your Honor. The commission did not find that there was any nefarious purpose, but the relevant question for the statute is whether the state is trying to give itself additional time, which it
seemed to me, if you give me just a second.
Of course.
My recollection is that one of the reasons for the withdrawal was that North Carolina couldn't prepare its conditions until the commission had finished its economic assessment. If I'm right about that, correct about that, isn't that a perfectly legitimate reason to delay?
So yes, Your Honor, you are correct that one of the reasons the state gave that for not being able to complete its review was that it needed both the commission's environmental assessment and also a water quality monitoring plan from the applicant. But that's from, and both the city of Fredericksburg and the New York State DEQ case say that a state cannot deem an application incomplete and start and restart the clock by saying that they don't have sufficient information. The bright line is 1 year from the date of receipt, which is March 3rd, 2017 here. So
what if it is incomplete? What if it in fact is incomplete? That means it has to be denied then, is that right?
That's right. It can be denied without prejudice if it is in fact incomplete.
Well, and if it's denied without prejudice, they can start over? I guess that's the choice you mean by without prejudice.
Exactly, Your Honor.
Well, that gets around the bright line rule.
Right. But yes, but our understanding, Your Honor, is that in that situation.
So it's not a bright line.
Right. Well, that's a court's one court's characterization of the 1 year period in Section 401. We recognize that there are instances where it's really not such a bright line, and the agency here is just trying to do the best it can to apply it to the facts of each individual case. And responding to something that Mr. Spiller mentioned, it is the commission's obligation to apply the statute to each case that comes before it. I mean, it has an independent obligation to apply the law, whether or not it's raised to the agency. So in this case, the commission.
Well, if you can do it without prejudice, there must be an element of equity that goes into this thing too then, right? So it's really not a bright line rule. You just call it a bright line rule.
Right. Well, the bright line rule language came from a Second Circuit decision, Your Honor. So it's not the commission's language. So I think it was, the court's effort to make clear that, this 1 year rule is there for a reason. It is there to prevent undue delay by the states. The Hoopa Valley Court made.
Well, yes, it's better on the merits, isn't it, as a general proposition, rather than throwing it out on some so-called bright line rule that's not always applied.
Right, Your Honor. Yes, well, on the merits, I mean, that's where the commission made its decision. It parsed the record and the communications, and it made the determination that what happened here was not an entirely voluntary withdrawal. The commission recognizes, and as you'll see from some of the commission's cases, the Village of Morrisville case and the KEI Maine case, the commission recognizes that there are instances where an applicant withdraws and resubmits its application for its own reasons, either for some strategic reason or because it has to examine the project or examine alternatives for the project. So that was the case in Morrisville, and none of those factors were present here. The commission made the decision that these resubmissions were not new resubmissions. They weren't new applications. There's nothing substantially changed about this application request from the time it was submitted in March 2017 to the time that North Carolina issued the water quality certificate in 2019. And I'll also note that this factual decision that the commission made about the applications not being new was not challenged in North Carolina's opening brief. So I think that issue is waived. What was challenged is the voluntariness of the withdrawals. And again, I think there is substantial evidence supporting the commission's decision that McMahon wasn't withdrawing its application here for its own reasons. It was doing it to accommodate the state. And our understanding of the law is that the state just can't give itself more time. It's not about whether the state is doing anything nefarious, but it can't give itself an extension under the law.
Ms. Chu, this is Judge Schraxer again. When North Carolina wanted a rehearing on the denial of their request. They submitted a declaration from one of their staff members that the commission dismissed as being unconvincing and irrelevant. On what factual basis did they make that decision?
Right, Your Honor, I think the commission found that the declaration submitted by Ms. Higgins was not helpful because it didn't actually show that the applicant's withdrawal was truly voluntary. There's actually no real dispute about the facts in this case. The communications are mostly email communications. There's some discussion of in-person meetings that North Carolina staff had with McMahon. But what we have is, the facts do show that the state first was viewing the application as incomplete, which even under City of Fredericksburg and New York State DEQ, we see that that's not the operative date. That's not, the trigger date is not when the state considers the application complete. It's when the state actually receives the application. Second, the record also shows that these withdrawals were preceded by communications from the state agency to the applicant saying that they wouldn't be able to complete the review in time. So it's in response to those communications and to the reminder emails.
But you say there's something nefarious about that.
Well, no, I mean, it's not.
You use it against them. You say there's nothing wrong with it, and then you say then you use it against them.
Right, Your Honor, I guess I mean that there's nothing nefarious, like immoral about it. There's nothing, it's just that the commission didn't make a determination that, that the state was doing this for some very bad purpose. It's just that the state was trying to give itself an extension, which is
found that.
I'm sorry, I didn't hear you, Your Honor.
I said in retrospect, then coming up here and arguing before us and trying to answer Judge Traxler's difficult questions, you may have been better off to have made such a finding.
Ms. Chu, this is Judge Traxler again. Did you finish, Judge King?
Yes, sir. You go right ahead.
Okay. Ms. Chu, when I step back and look at this case, and it's apparently clear that there's no nefarious purpose in these extensions and discussions that have been going on between North Carolina and McMahon. The delays appear legitimate, and there's no objection to these conditions that North Carolina wants to add in. I don't understand where the problem is.
Right, Your Honor, the problem is Section 401 of the Clean Water Act and the federal regulatory licensing scheme that Congress was intending to protect. Well, I said it's there was no nefarious purpose. The law just makes clear that the state is not allowed to give itself more time than 1 year. And that's where the commission made the difficult determination on the facts that the state was trying to give itself more time here. It did have all of the information that was required to issue a decision, and it could have issued a decision earlier than it did. It could have issued a decision within the 1 year period, or it could have denied without prejudice. So with that understanding, the commission made the decision that the state had waived its certification authority.
Well, it sounds to me that either method you choose to extend the time is just playing games. It's either denying without prejudice, which means nothing, or it's giving an extension, which means nothing.
Right, Your Honor, I think that's
you look like
that's the result of the statute.
Ms. Chu, you're saying that there's a straw man or kind of thing in here, or front person situation, that they're the ones the spokesman for the other.
I'm not sure I know what you mean, Your Honor, about a straw man.
Well, I don't know. I'm just using that. But we get these things that come up here in these criminal cases. There's different language spoken, but
okay. Yes.
One's the front. You're saying that's what it is, and that usually involves nefarious conduct. And you specifically disavow any nefarious conduct. But you say it's all right to give a dismissal without prejudice, and that would accomplish the same thing.
Right, and that's the commission's understanding from the New York State DEQ decision that a denial without prejudice is legitimate under the statute. But under other case law, a withdrawal and resubmission of the same application is not legitimate. It's just not permitted. So I do think,
Anything else? Do you have anything else?
Briefly, I think I should address the jurisdictional arguments that Mr. Moore has raised. I just wanted to point out that this is not an ordinary property. When PK Ventures bought this dam, it was a licensed hydroelectric project. And to Judge Thacker's question, no, the PK Ventures did not file an application for a license with FERC. It actually, in 2013, filed a notice of intent to file a license application, but thereafter it failed to file the application itself. And at JA 287, Your Honor, there is a commission order granting a request by PK Ventures to revoke a license transfer, because previously the commission had transferred the license from the previous owner to PK Ventures when PK Ventures purchased the property. So I'm not really sure what PK Ventures' stake in this litigation is, apart from its ownership. I understand that they are concerned about eminent domain, but they did not file the FERC license, and this is the this is a property that was a licensed hydropower project, and it's being used for the benefit of the residents of North Carolina. It's the development of a project on a national resource, the Haw River. And I think our briefs demonstrate why FERC has jurisdiction to issue the license.
Yes.
Ms. Chu.
I'm sorry, go ahead.
Ms. Chu, this is Judge Traxler again. I'm getting even more confused. I'm looking at a decision from FERC. It's KEI Main Power, a 2020 FERC decision, where they concluded that a withdrawal and submission by the applicant did not give rise to a waiver because the withdrawal was not done at the behest of the state agency. And they reached this conclusion despite the existence of an email from the agency telling the applicant to, quote, submit what you have along with the statement regarding withdrawal and resubmit. Once you've withdrawn and resubmitted, you can then submit additional comments. Now, tell me what the difference is between what FERC approved in this KEI Main case and what's going on in this case.
Sure, Your Honor. So KEI Main was a different case. In that case, the applicant withdrew and resubmitted in order to get additional time to negotiate some fish passage measures. So it was in settlement discussions, various negotiations with different state and federal agencies. So
the reason was, the difference is the reason they're withdrawing and resubmitting, that's what's important, the reason?
Right. It was voluntary. It was a voluntary withdrawal for the benefit of the applicant, not for the benefit of the state. And it wasn't direct, it's for the benefit of the applicant primarily.
Isn't the benefit of, I'm confused. Right. I'll give up.
I'm sorry, Your Honor. I don't, I would love to help clarify the distinctions between Morrisville and KEI Main and this case. I understand that the fact patterns get a little complicated. I mean, Morrisville is another example. If I could just briefly touch on it. It was a situation where the applicant withdrew and reapplied, but it was doing so because it was looking at a possible change to the project, a possible physical change involving the use of microturbines. It was looking at flow studies. It was preparing cost-benefit analyses of different water quality certification conditions. So it was again, that withdrawal was because the applicant wanted to give itself more time. And the difference here is that the state was trying to give itself more time, which it's not allowed to do under Section 401, as interpreted by the courts. I understand your
Anything else, Mr.
No, I understand that this is this case involves a lot of fact parsing. And I just want to say the commission did the best it could to parse all of these facts consistent with the statutory language as interpreted by the courts of appeals. And I don't think that this case represents a reason for departing from the decisions in Hoopa Valley or New York State DEQ, which I recognize are not binding on this course, but I believe that it's that this case is in line with those cases. Thank you.
Thank you very much, Ms. Chu. We appreciate it.
Thank you.
Good to have you with us. Mr. Moore? Are
Yes,
you
Your
out
Honor.
there, Mr. Moore?
Yes, sir.
Okay.
1 minute rebuttal. What we just heard on this Clean Water Act 401 issue to me was, frankly, it sounds like a fight between two governments on a matter of principle, because North Carolina issued that 401 basically the next day after the license order was issued. And here we are taking the time of the Fourth Circuit, and I don't know how many states we've got involved in this, for something that really is just a fight on a matter of principle between two governments. The real issue, Your Honor, is it, does FERC have jurisdiction? And the answer is no. FERC's position is dangerous. If their position prevails that any project that will affect interstate commerce in the future, if that's correct, first, Nantahala has got to be distinguished. In this case, Union Electric, the Supreme Court case, has got to be distinguished as well. And this is a dangerous precedent for property in the United States and for property owners. We have a right not to produce hydropower. That's a right that we have under the Constitution, and we ask the court to not render an advisory opinion on the 401, but to rule on the jurisdictional matters that we've raised. Thank you.
Thank you, Mr. Moore. Mr. Spiller?
Thank you, Your Honor. Just a few brief points. Ms. Chu repeatedly stated that the state is trying to give itself more time. And that's simply not an accurate characterization of the record. DEQ did not direct McMahon to withdraw and resubmit its certification request. If McMahon had not withdrawn and resubmitted, DEQ certainly would have acted on McMahon's certification request and may well have done what Ms. Chu said is authorized under the statute, which is to issue a denial without prejudice. The applicant made a choice that rather than allow the state to do that, it wished to withdraw and resubmit to restart the statutory clock. So we take issue with the characterization of the record. The other point I want to make is that the commission has repeatedly stated that this was not entirely voluntary. And yet at the same time, they, as Judge Traxler pointed out, they dismiss outright Ms. Higgins' declaration in this case, which expressly goes to that issue. Ms. Higgins explained that DEQ never directed McMahon to withdraw and resubmit his certification request. That was a choice that the applicant made. And then the final point I wanted to make, Your Honors, is that the commission argues that DEQ is claiming that we get to say when the 1 year period starts, and that's whenever we deem the application complete. And that we've never made that argument in this case. The commission acknowledges that the department, DEQ, can deny a certification request if it lacks sufficient information to ensure compliance with water quality standards. In this case, DEQ may very well have done that. McMahon chose to withdraw and resubmit to give itself more time and to give the commission more time to produce the information that DEQ needed to issue a certification, which it ultimately did with conditions that the state deemed necessary to ensure protection of water quality. And unless the court has further questions, I'll just briefly conclude. The commission's—
I got a question. I have a brief question for you. It's a little bit off the point, maybe you might think, but this is part of the Cape Fear watershed, this Haw River, correct?
Correct, Your Honor.
how many how many dams are there between this Byron Dam and the Atlantic Ocean down there at Wilmington?
I apologize, Your Honor. I don't know the answer to that.
Well, you're the North Carolina guy. That's the reason I was asking the question for you. Oh my! All right, go ahead, finish up.
Yeah, I'll just briefly close. So the commission's "we know it when we see it" test not only conflicts with Section 401, it provides states with no guidance as to how to ensure that their statutory authority to protect their waters is not deemed waived. And we simply ask that the court apply the statutory text and vacate the commission's waiver decision in this case so that North Carolina's 401 certification and the water quality protections it imposes can take effect. Thank you very much.
Thank you, sir, very much. And if we were in Richmond, we'd members of the panel would come down and we'd tell all three of you that you've done a good job. And it was good to have you here. We're not able to do that, so we'll just adjourn court for the day, and perhaps for some of us for the week. Madam Clerk, would you do that, please?
Yes, sir. This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank you.
Thank you.